You may be seated.
Members of the jury, it is now my duty to instruct you about the applicable law so you can perform your duty of deciding the disputed issues of fact in this case. You must follow the law as I stated to you, whether you agree with it personally or not. What the lawyers may have said or suggested what the law is not necessarily the law. It is my responsibility and mine alone to instruct you as to what the law is and how you must apply the law to the facts that will be your responsibility to find in this case. You will notice that I'm reading these instructions to you. I apologize for doing so, but I must give these instructions completely, clearly, and accurately to assist you in your deliberations. To assist you in your deliberations, I will provide you with a written copy of these instructions. However, the written instructions are not a substitute for these oral instructions, so please listen carefully. And I note that you have listened to me carefully throughout the entirety of this trial, as well as the lawyers and the witnesses, and for that we're very grateful, and I want to thank you on behalf of the lawyers and myself. All of these instructions are equally important. You are not to overemphasize one portion of these instructions or ignore other portions. Although these proceedings have been recorded, we do not have written transcripts of any portion of the trial testimony to give you for your deliberations. You must therefore use and rely on your collective memories of the evidence in this case, perhaps assisted by your notes. Please remember, your notes are only an aid to your memory. They are not a substitute for what you remember. Your notes should not be considered by any of you as a verbatim record of what you may have seen or heard during the trial. You should use your notes only to assist you to recall what you may have seen or heard during the trial. Do not be unduly influenced by the notes of other jurors. During your deliberations, you are not to show your notes to anyone other than your fellow jurors. And at the end of each day, if you happen to be deliberating at the end of the day that you may be deliberating, your notes will be kept in a safe place until such time as you reconvene and resume your deliberations. Those notes have not been and will not be reviewed or examined by anyone, me included. After you've reached and returned your verdicts, I will direct the court officers to collect and completely destroy any notes you may have made in this case. I'm first going to talk to you about some general legal principles that apply to all criminal cases, and then I will turn to matters of law that are applicable to this case. First, let me discuss with you some general principles. Indeed, these are fundamental principles that apply to all criminal cases, and they are the presumption of innocence, the burden of proof, and the concept of reasonable doubt. This is a criminal case, and as you know, it is a cornerstone of our democracy that any person charged with a crime is presumed to be innocent until he or she is proven guilty beyond a reasonable doubt. That is a presumption that belongs to each of you. It is a presumption that belongs to me, and it is a presumption that belongs to Blake Scanlon in this case. The fact that Mr. Scanlon has been charged with a crime, indicted for a crime, or arrested for a crime is absolutely no evidence whatsoever that that individual is guilty of any crime. As I explained to you at the outset of this trial, and as I emphasize to you again now, an indictment is only an accusation. It is a procedural vehicle which brings a person before the court so that the person may stand trial, so that a jury like you may determine whether that person is guilty or not guilty. That is all an indictment is. The presumption of innocence also means that no person ever has to prove his or her innocence. No person charged with a crime ever has to explain anything to a jury. Exactly the contrary is true. It is the Commonwealth, it is the government, it is the prosecution, which must prove each and every element of a particular crime beyond a reasonable doubt before that person may be found guilty of that crime. If the government does not prove each and every element of a particular crime charged beyond a reasonable doubt, then you, the jury, must find the defendant not guilty of that crime. This burden of proof never shifts. The defendant is not required to call any witnesses or produce any evidence, since the defendant is presumed to be innocent. The presumption of innocence stays with Mr. Scanlon until and unless the evidence convinces you unanimously as a jury that the defendant is guilty beyond a reasonable doubt. It requires you to find Mr. Scanlon not guilty unless his guilt has been proved beyond a reasonable doubt. The presumption of innocence alone is sufficient to acquit Blake Scanlon unless you are satisfied beyond a reasonable doubt of his guilt after careful and impartial consideration of all the evidence presented during this trial. That brings me now to the concept of reasonable doubt. The burden is on the Commonwealth to prove beyond a reasonable doubt that Mr. Scanlon is guilty of the charges made against him. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, although it is not easily defined. proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true based solely on the evidence that has been put before you in this trial. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs. I have told you that every person is presumed to be innocent until he or she is proved guilty, and that the burden of proof is on the government. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant, Mr. Scanlon, is entitled to the benefit of that doubt and must be found not guilty. It is not enough for the Commonwealth to establish a probability or even a strong probability that Mr. Scanlon is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. That is what we mean by proof beyond a reasonable doubt. Now, let me explain to you about matters that may have occurred or arisen during the trial of this case, and about the evidence and what you may do with the evidence you have heard in this case. So, let me explain to you again what the respective roles of the attorneys in this trial are. The attorneys have very solemn and important responsibilities. It is their role to present evidence helpful to their clients' respective positions. It is also the duty of counsel to object when evidence is offered that they believe may be inadmissible under our rules of evidence. And the way those matters have been handled, as you have observed, is that I have either ruled on the objection from the bench and the case has proceeded, or we have had a discussion at sidebar where I have addressed the matter of the law at issue, made a decision, and the case has moved forward. I don't think I have to point out to you that any such activity on the part of any attorneys in making an objection or in requesting a sidebar conference is not to be held against either the Commonwealth or Mr. Scanlon in your consideration of the evidence or in your deliberations of your verdict. Each of the attorneys is carrying out his or her duties, obligations, and responsibilities as advocates. My role as the judge of this case has been to see that there has been a fair, orderly, and efficient trial of this case, and to rule on questions of evidence and matters of law that come up during the trial, and now finally to instruct you, that is, give you the law of the case. Since determining the facts in this case are your duty and your responsibility alone and not mine, let me remind you that you are to draw no inferences, favorable or unfavorable, to any party because of anything I may have said or done during the course of this trial. If you somehow think that during the course of the trial I made certain rulings that suggested how I felt the case was going in, or how any issue of fact should be resolved, or how you should find these facts, then you are to ignore it, because that would be improper for me to do that. I do not intend to do that, and the decision you must make on what the facts are in this case must be free from interference from anyone, myself included. Your job, which turns our attention now to the role of the jury. Your role is the most important role in the trial of this case, because you and you alone will determine what the facts are. In a sense, you are judges when you do that. You are the sole and exclusive judges of the facts in this case. It does not matter what I or the lawyers think the facts are. All that matters is what you, the jury, find the facts to be. In deciding what the facts are, you all have certain tools available to you. The main ones are your own good judgment, common sense, and general life experiences. Bring those tools with you into the jury room and use them as you work to reach a verdict. You alone, jurors, determine the weight, the effect, and the value of the evidence, and the credibility, and the word means the believability of the witnesses who have testified before you. Once you make those determinations of fact, it is then your duty to apply them to the law that I give you. If at any time attorneys called your attention to matters of evidence that you do not remember collectively as a jury, then you are free to ignore it, because it is your memory of what the evidence is that controls your deliberations in this case. In deciding whether Mr. Scanlon is guilty or not guilty, you should act without bias or prejudice, without fear or favor, and make your judgment solely from a fair consideration of the evidence. Emotion or sympathy for one side or the other has no place whatsoever in your deliberations. You are not to decide this case based upon guesswork or speculation or suspicion, or any unanswered questions in your mind. You may not speculate as to what might be or might not have been with respect to the facts, and you must not be influenced by the popularity or lack of popularity of the crime charged. You are not to decide this case on the basis of what you may have learned or heard outside of this courtroom. Rather, you must confine your consideration to the evidence and nothing but the evidence, and your decision must be based on common sense, good reasoning, and good judgment. Your decision must be made without partiality and without concern for the consequences of your decision. So let's turn to another important issue that I raised with you at the beginning of this trial. Our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, education, income level, or any other personal characteristic. You have all agreed to be fair. I am sure that you want to be fair, but that is not always easy. One difficulty comes from our own built-in expectations and assumptions. Those assumptions exist even if we're not aware of them, and even if we believe we do not have them. Some of you may have heard this called implicit bias, and that is what I am talking about. We judges have the same problem, so let me share a few strategies that we have found to be helpful in this situation. First, slow down. Do not rush to a decision. Hasty decisions are the most likely to reflect stereotypes or hidden biases. Take time to consider all of the evidence. Second, as you start to draw conclusions, consider what evidence, if any, supports the conclusions you are drawing, and whether any evidence casts doubt on those conclusions. Double check whether you are using unsupported assumptions instead of the evidence. Third strategy, as you think about the people involved in this case, consider them as individuals rather than as members of a particular group. Fourth, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? Fifth, listen to your fellow jurors. They may have different points of view. If so, they may help you determine whether you are focusing on the facts or making assumptions, perhaps based upon stereotypes. Of course, your fellow jurors could be influenced by their own unstated assumptions, so don't be shy or hesitate to speak up during your deliberations. You should participate actively, particularly if you think the other jurors are overlooking or undervaluing evidence you find important. In fact, when you explain your thoughts out loud to other jurors, you are also helping yourself to focus on the evidence instead of assumptions. If you use these strategies, then you will do your part to reach a decision that is as fair as humanly possible. That is all we ask. That is your responsibility as jurors. Let me tell you what evidence is, and equally important, what is not evidence in the case. The law does not require any particular type of evidence. Evidence may be testimonial, documentary, physical, as well as forensic or scientific. Evidence is what you have heard from the mouths of the witnesses who have testified before you under oath and given answers to the questions put to them by the attorneys on direct and cross-examination. You have all had the chance to listen to each witness, to observe each witness, to consider all of what he or she has said and how they've said it, and that is evidence. Evidence also includes photographs, discs, documents, and other items received into evidence and marked as exhibits during the trial. The quality or strength of the proof is not determined by the sheer volume of the evidence or by the number of witnesses presented at trial. Rather, it is the weight of the evidence, that is, its strength intending to prove the issues at stake, that is important. You should consider all of the facts and the circumstances in evidence and all the witnesses that may have been presented in determining whether the Commonwealth has proved each of the elements of the crimes charged against Mr. Scanlon in this case beyond a reasonable doubt. So some things in this case have occurred that are not evidence, and you may not consider these things in deciding this case. As I've already told you, the indictments in this case are not evidence. A question put to a witness by counsel, no matter how suggestive it might be or how artfully phrased, is not evidence. It's the answer to the question, and only the answer to the question, that is evidence. Also, you may not consider, and you must not consider, and shall not consider as evidence any question, answer, or other matter that I ordered stricken from the record and told you to disregard during the trial. You may not consider any items or things that were only marked for identification but never marked as exhibits in the trial, and those matters marked for identification will not be with you in the jury room. The opening statements and closing arguments of counsel are important, helpful, appropriate, but they're not evidence in the case. The personal beliefs of me or counsel of this case on any issue in this case, on what the evidence is not evidence. Anything you may have seen or heard outside this courtroom or while you were not sitting in the courtroom is not evidence. My instructions to you that I'm reading to you now is not evidence. Consider the body of evidence as a whole. Don't make up your minds about what the verdict should be until after you've returned to the jury room to decide this case and you and your fellow deliberating jurors have discussed all of the evidence thoroughly, thoughtfully, and carefully. There are two types of evidence in a trial that you may use to determine the facts in this case. There's direct evidence and circumstantial evidence. The law allows both direct and circumstantial evidence in a criminal case, and circumstantial evidence alone may be sufficient to establish guilt beyond a reasonable doubt. Direct evidence is when a witness testifies directly about the fact that is sought to be proved and based upon what he or she claims to have seen, heard, or felt with his or her own senses. And the question then is whether you believe that witness or not. Circumstantial evidence is when no witness can testify directly about the fact that is sought to be proved, but you are presented with evidence of other facts and then asked to draw reasonable inferences from them about the fact that is sought to be proved. An inference is a permissible deduction that you may make from the evidence that you have accepted as believable. Inferences are things that you do every day, that we all do every day. Little steps in reasoning in which you take some known information, apply your common sense and general life experience to it, and then draw a conclusion from it. There are, however, several things you should keep in mind about circumstantial evidence. The first one is that you may draw inferences and conclusions only from facts proved to you beyond a reasonable doubt. The second rule is that any inferences or conclusions you draw must be reasonable, natural, based upon your common sense, good judgment, and general life experiences. In a chain of circumstantial evidence, it is not required that every one of your inferences and conclusions be inevitable, but it is required that each of the inferences drawn must be reasonable, and that they all be consistent with one another, and that together they establish the defendant's guilt beyond a reasonable doubt. Inferences must never be based upon conjecture, surmise, guesswork, or assumption, and whether the evidence is direct or circumstantial, the Commonwealth must prove Mr. Scanlon's guilt beyond a reasonable doubt from all the evidence in this case. Jurors, you have heard evidence suggesting that Mr. Scanlon may have done or said certain things that may be considered as consciousness of guilt. If the Commonwealth has established these, you may consider whether such actions indicate feelings of guilt by Mr. Scanlon, and whether in turn such feelings of guilt might tend to show actual guilt on these charges. You are not required to draw inferences, and you must not do so unless they appear to be reasonable, considering all of the circumstances in this case. If you decide that such inferences are reasonable, it will be entirely up to you to decide how much importance to give them. However, you should always remember that there may be numerous reasons why an innocent person might do such thing. Such conduct does not necessarily reflect feelings of guilt. Please also bear in mind that a person having feelings of guilt is not necessarily guilty. In fact, for such feelings are sometimes found in innocent people. Finally, remember that standing alone, such evidence is never enough by itself to convict a person of a crime. You may not find Mr. Scanlon guilty on such evidence alone, but you may consider it in your deliberations along with all of the other evidence in this case. Witness credibility. As I told you when we started today, it is your function, among others, to decide the credibility, that is, the believability of witnesses. In determining credibility and the weight to be given to the testimony of a witness, you should consider and may be guided by such factors as the conduct and demeanor of the witness while testifying, the frankness or lack of frankness of that witness, the reasonableness or unreasonableness of the testimony, the probability or improbability of that testimony, the opportunity or lack thereof to see or to know the facts to which the witness has testified, and the accuracy of the witness's memory, as well as the degree of intelligence demonstrated by the witness on the stand. You may also consider the witness's motive to testify for or against the Commonwealth or the defendant, and of course the interest or lack of interest of the witness in the outcome of this case. You may also take into consideration the age and character and appearance of the witness at the trial, as well as any bias he or she has shown for or against either Mr. Scanlon or the Commonwealth in their testimony, in determining the credit to be given to that particular witness's testimony. In evaluating a witness's credibility, you may take into consideration any benefit a witness received or any hopes You should consider the testimony of a police officer or other law enforcement officer just as you would consider all the other testimony in this case, and you should use the same guidelines you apply to the testimony of any witness. In no event should you give any greater or lesser credence to the testimony of a witness just because he or she is a police or law enforcement officer. Now, as I've told you, you, the jurors, have great power in this regard. In evaluating the testimony presented by a witness, you are free to believe everything that a witness says, some of what a witness says, or none of what a witness says. If there are any conflicts in the testimony, it is your responsibility to resolve that conflict. Now, the Commonwealth has introduced certain photographs showing Ms. Avery. The photographs are not pleasant. Indeed, they may be described as graphic. I instruct you that your verdict must not in any way be influenced by the fact that these photographs may be unpleasant or graphic. Mr. Scanlon is entitled to a verdict based solely on the evidence and not one based upon pity or sympathy for Ms. Avery, which might be occasioned by the photographs. Consider those exhibits only as they draw attention to a clinical medical status or to the nature of Ms. Avery's alleged injuries or to the nature of the incident itself. During this trial, you've heard testimony from certain witnesses that we call expert witnesses. Ordinarily, a witness may testify only to things that he or she has either saw or heard or somehow sensed, but when matters are brought out that are technical in nature or beyond the knowledge of the average person, a witness may be called to give his or her opinion to assist the jurors in understanding the evidence. Such expert opinion evidence is subject, however, to the same rules that I told you about with respect to other witnesses. That is, you may believe all of it, none of it, or anything in between those two extremes. There is no obligation for you to believe or disbelieve an expert witness merely because that person testified as an expert. In considering an expert witness's testimony, you may consider the witness's education, training, experience, and background. You are also free to accept or reject the expert's testimony in whole or in part if you are not satisfied that it is based upon the facts of the case as you find them to be, or if you find that the expert does not have a sufficient basis in fact upon which to support the opinion, or if you find that the expert has not had sufficient opportunity to observe that which the expert purports to have observed, or if you find that the opinion is motivated by bias or by the expert's own interest in the case. Please remember, with respect to experts, that expert witnesses do not decide cases, juries do. In the last analysis, an expert witness is like any other witness in the sense that you alone make the judgment about how much credibility and weight you give the expert's testimony, and then what conclusions you all draw from the testimony. Prior inconsistent statements. When you evaluate the testimony of that a witness gave here in court, you may consider whether the witness made an earlier out-of-court statement that differs from or contradicts in any way his or her in-court testimony. An earlier unsworn statement, such as a statement made to a police officer or an investigator, is admitted into evidence solely for your consideration in evaluating the witness's believability. If you determine that an earlier statement is different from the way the witness testified in court, you may decide that the witness's believability is affected adversely, or you may decide that it is not affected adversely. But that is the only purpose for which you may use the earlier statement. You may not consider the out-of-court statement as evidence or proof of the truth of any fact contained in the out-of-court statement. However, when a witness's out-of-court statement was made under oath, you may consider that evidence substantively. Other acts, state of mind. As I instructed earlier, Mr. Scanlon is not charged with committing any act or crimes other than the charges that are before you in this case. You heard testimony about alleged other criminal acts Mr. Scanlon was allegedly involved in. That evidence was admitted for a limited purpose only. If you find this evidence credible, you may consider it only on the issues of Mr. Scanlon's state of mind, intentions, or the existence of a plan or scheme during the time of the alleged crime. You may not use this evidence as substitute proof that Mr. Scanlon committed the crimes with which he has been charged in this case. You cannot use this evidence as proof that Mr. Scanlon is a man of bad character with a propensity to commit criminal acts. Rather, as I said, it is only relevant on Mr. Scanlon's state of mind, his intention, or the existence of a plan or common scheme. You may not consider the evidence for any other purpose, and specifically I instruct you that you may not use it to conclude that if Mr. Scanlon was involved in those other acts, he must also have committed the crimes with which he is now charged. You may have observed during this trial that Mr. Scanlon did not testify. Mr. Scanlon, as I told you twice, when I told you this one before we picked the jury, and I told you again during the pre-charge, Mr. Scanlon has an absolute right not to testify since the entire burden of proof is on the Commonwealth to prove that the defendant is guilty. It is not up to Mr. Scanlon to prove that he is innocent. In this case, Mr. Scanlon has exercised his lawful right not to take the witness stand. The fact that he is elected not to testify is in no way to be regarded by you as involving the question of his innocence or his guilt. You may not draw any negative inferences from this fact and decision. I instruct you that in the jury room, you may not speculate about why he did not take the stand. I've told you why. He has exercised his constitutional and lawful right. The fact that Mr. Scanlon did not testify has absolutely nothing to do with the question of whether he is guilty or not guilty of any offense. So you are not to consider in any way or even discuss it in your deliberations in the jury room. You must determine whether the Commonwealth has proved its case against Mr. Scanlon based solely on the testimony of the witnesses and the exhibits and evidence in the trial of this case. Now I'm going to give you the law on the charges in this case. For your purposes, they begin at page 22 of what I am reading now. The Commonwealth alleges that on or about January 12, 2019, Mr. Scanlon murdered Ms. Alexis Avery. Mr. Scanlon has denied the accusation and has pled not guilty to this charge. It will be your duty to determine whether the Commonwealth has proved beyond a reasonable doubt that Mr. Scanlon is guilty. Murder is the unlawful killing of a human being. There are 2 degrees of murder, murder in the first degree and murder in the second degree. Mr. Scanlon is charged with the first-degree murder of Ms. Avery. To convict Mr. Scanlon of this charge, the Commonwealth must prove beyond a reasonable doubt each of the elements of first-degree murder. If the Commonwealth fails to prove first-degree murder beyond a reasonable doubt, you must then consider and determine whether it has proven all the elements of second-degree murder against Mr. Scanlon beyond a reasonable doubt. If the Commonwealth fails to prove all the elements of either first-degree murder or second-degree murder against Mr. Scanlon beyond a reasonable doubt, then you must find Mr. Scanlon not guilty of this charge. The Commonwealth alleges that Mr. Scanlon committed murder in the first degree on the following 2 theories. 1, murder with deliberate premeditation, and 2, murder with extreme atrocity or cruelty. To prove Mr. Scanlon guilty of murder in the first degree with deliberate premeditation, the Commonwealth must prove beyond a reasonable doubt the following elements. First, Mr. Scanlon caused the death of Mr. Avery. Second, Mr. Scanlon intended to kill Ms. Avery, that is, he consciously and purposely intended to cause Ms. Avery's death. And 3, Mr. Scanlon committed the killing with deliberate premeditation, that is, he decided to kill after a period of reflection. The first element is that Mr. Scanlon caused the death of Ms. Avery. A defendant's act is the cause of death, where the act, in a natural and continuous sequence, results in death, and without which death would not have occurred. The second element that is that Mr. Scanlon intended to kill Ms. Avery, that is, the defendant consciously and purposely intended to cause Ms. Avery's death. Intent refers to a person's objectives or purposes. By this I mean that Mr. Scanlon must have had it in his mind to do the prescribed act. It involves concentrating or focusing the mind for some perceptible period. It is a conscious act with the determination of the mind to do an act. It is contemplation rather than reflection, and it must precede the act. In determining whether Mr. Scanlon acted intentionally, you should give the word its ordinary meaning of acting voluntarily and deliberately, and not because of accident or negligence. Intent is essentially a state of mind. It means the purpose or objective of a person at the time of the action. The intention of a person is to be ascertained by his acts, and the inferences to be drawn from what is externally visible. Intent ordinarily cannot be proved directly because there is no way of reaching into and examining the operations of the human mind. However, you may determine Mr. Scanlon's intent from any statements or act committed or omitted, and from all other circumstances that indicate his state of mind, provided first that you find that any or all such circumstances occurred. You may, but need not necessarily, infer from the conduct of a person that he intended the natural and probable consequences of his own act. There are 2 forms of intent, general and specific. General intent is when we do things more or less unconsciously, such as sitting down in a chair. We would not do it unless our mind first resolved to do it, but it does not require any concentration or focusing of the mind. Specific intent is the act of concentrating or focusing the mind for some perceptible period. It is a conscious act and the determination of the mind to do an act. It is contemplation rather than reflex, and it must precede the act. Here, Mr. Scanlon must have specifically intended to kill Ms. Avery. Specific intent is a matter of fact which may or may not be proven by direct evidence. If it is not proven by direct evidence, then you may or may not infer the specific intent from Mr. Scanlon's conduct. You may consider all the surrounding facts and circumstances and weigh them in light of your common knowledge and experience in order to determine whether or not to draw the inference that the defendant specifically intended to kill Ms. Avery. The third element is that Mr. Scanlon committed the killing with deliberate premeditation. That is, he decided to kill after a period of reflection. Deliberate premeditation does not require any particular length of time of reflection. A decision to kill may be formed over a period of days, hours, or even a few seconds. The key is the sequence of the thought process. First, the consideration whether to kill. Second, the decision to kill. And third, the killing arising from the decision. There is no deliberate premeditation where the action is taken so quickly that a defendant takes no time to reflect on the action and then decides to do it. If after your consideration of all the evidence in this case you find that the Commonwealth has proved beyond a reasonable doubt each of the three elements I've just defined for you, then you shall find Mr. Scanlon guilty of murder in the first degree committed with deliberate premeditation. If, however, after your consideration of all the evidence you find that the Commonwealth has not proved each of the three elements beyond a reasonable doubt, then you must not find the defendant guilty of first-degree murder under the theory of a deliberate premeditation. Regardless of your decision, you must next turn your attention to whether the Commonwealth has proven beyond a reasonable doubt that Mr. Scanlon murdered Ms. Avery with extreme atrocity or cruelty. The second, separate and independent theory for first-degree murder is murder with extreme atrocity or cruelty. As noted, you must consider this theory of murder in the first degree whether or not you find that the Commonwealth has proved murder in the first degree with deliberate premeditation. That is, you must consider both theories. To prove Mr. Scanlon guilty of murder with extreme atrocity or cruelty, the Commonwealth must prove the following elements beyond a reasonable doubt. First, Mr. Scanlon caused the death of Ms. Avery. Second, Mr. Scanlon either A, intended to kill Ms. Avery, or B, intended to cause grievous bodily harm to Ms. Avery, or C, intended to do an act which in the circumstances known to Mr. Scanlon, a reasonable person would have known created a plain and strong likelihood that death would result or shared that intent. And third, the killing was committed with extreme atrocity or cruelty. Each of those elements that I described to you must be proved beyond a reasonable doubt in order to convict Mr. Scanlon of this theory of murder. The first element is that Mr. Scanlon caused the death of Ms. Avery. Please refer to my earlier instructions on this element as they are applicable here. The second element is that Mr. Scanlon, A, intended to kill Ms. Avery, or B, intended to cause grievous bodily harm to Ms. Avery, or C, intended to do an act which under the circumstances known to Mr. Scanlon, a reasonable person would have known created a plain and strong likelihood that death would result or shared that intent. As you can see, this second element has three sub-elements, A, B, and C, which we refer to as prongs, and the Commonwealth satisfies its burden of proof if it proves any one of the three prongs beyond a reasonable doubt. The first prong, that Mr. Scanlon intended to kill, is the same as I previously instructed you on murder with deliberate premeditation, and those instructions are equally applicable here. The second and third prongs are different from any element of murder in the first degree with deliberate premeditation. The second prong, which I'll explain to you now, is that Mr. Scanlon intended to cause grievous bodily harm to Ms. Avery. Grievous bodily harm means severe injury to the body. The third prong is that Mr. Scanlon intended to do an act which in the circumstances known to him, a reasonable person would have known created a plain and strong likelihood that death would result. When considering this third prong, you must first determine whether Mr. Scanlon intended to perform the act that caused Ms. Avery's death. If you find that he intended to perform the act, you must then determine what Mr. Scanlon himself actually knew about the relevant circumstances at the time he acted. Then you must determine whether, under the circumstances known to him, a reasonable person would have known that the act intended by Mr. Scanlon created a plain and strong likelihood that death would result. The third element is that the killing was committed with extreme atrocity or cruelty. Extreme atrocity means an act that is extremely wicked or brutal, appalling, horrifying, or utterly revolting. Extreme cruelty means that Mr. Scanlon caused the person's death by a method that surpassed the cruelty inherent in the taking of human life. You must determine whether the method or mode of killing is so shocking as to amount to murder with extreme atrocity or cruelty. The inquiry focuses on Mr. Scanlon's actions in terms of the manner and the means of inflicting death and on the resulting effect. In deciding whether the Commonwealth has proved beyond a reasonable doubt that Mr. Scanlon caused the death of Ms. Avery with extreme atrocity or cruelty, you must consider the following factors. 1, whether Mr. Scanlon was indifferent to or took pleasure in the suffering of the deceased. 2, the extent of the injuries to the deceased. 3, the number of blows delivered. 4, the manner, degree, and severity of the force used. 5, the nature of the weapon, instrument, or method used. And 6, the disproportion between the means needed to cause death and those employed. This factor refers to whether the means used were excessive and out of proportion to what would be needed to kill a person. You cannot make a finding of extreme atrocity or cruelty unless it is based upon one or more of the factors I've just described. If after your consideration of all the evidence in this case, you find that the Commonwealth has proven beyond a reasonable doubt each of those elements I've defined for you, then you shall find Mr. Scanlon guilty of murder in the first degree committed with extreme atrocity or cruelty. If, however, after your consideration of the evidence, you find that the Commonwealth has not proven each of the 3 elements beyond a reasonable doubt, you must not find Mr. Scanlon guilty of first-degree murder under the theory of extreme atrocity or cruelty. Second-degree murder. To prove Mr. Scanlon guilty of second-degree murder, the Commonwealth must prove beyond a reasonable doubt the following 2 elements. First, Mr. Scanlon caused the death of Ms. Avery, and this is on page 31 of these instructions. First, Mr. Scanlon caused the death of Ms. Avery, and second, Mr. Scanlon either intended to kill Ms. Avery, or B, intended to cause grievous bodily harm to Ms. Avery, or C, intended to do an act which in the circumstances known to Mr. Scanlon, a reasonable person would have known created a plain and strong likelihood that death would result, or shared the intent. As you can see, these elements are the same as the first 2 elements of murder with extreme atrocity or cruelty, and you should refer to those instructions. In addition, as a general rule, you are permitted but not required to infer that a person who intentionally uses a dangerous weapon on another person intends to kill that person or cause her grievous bodily harm, or intends to do an act which in the circumstances known to him a reasonable person would know creates a plain and strong likelihood that death would result. If after your consideration of all the evidence in this case, you find that the Commonwealth has proven beyond a reasonable doubt each of these 2 elements, then you shall find Mr. Scanlon guilty of murder in the second degree. If, however, after your consideration of all the evidence, you find that the Commonwealth has not proved has not proved one or more of the elements beyond a reasonable doubt, then you must find Mr. Scanlon not guilty of second-degree murder. Turning our attention now to voluntary manslaughter. To prove Mr. Scanlon guilty of murder in the first or second degree, the Commonwealth is required to prove beyond a reasonable doubt that there were no mitigating circumstances that reduced Mr. Scanlon's culpability. A mitigating circumstance is a circumstance that reduces the seriousness of the offense in the eyes of the law. A killing that would otherwise be murder in the first or second degree is reduced to the lesser offense of voluntary manslaughter, where the Commonwealth has failed to prove that there were no mitigating circumstances. Therefore, if the Commonwealth proves all the required elements of murder, but fails to prove beyond a reasonable doubt that there were no mitigating circumstances, you must not find Mr. Scanlon guilty of murder, but you shall find Mr. Scanlon guilty of voluntary manslaughter. Voluntary manslaughter is not a defense, it's a mitigation. A mitigating circumstance for you to consider is what the law calls heat of passion. Heat of passion includes the states of mind of passion, anger, fear, fright, and nervous excitement. Reasonable provocation is provocation by a person killed that would be likely to produce such a state of passion, anger, fear, fright, or nervous excitement in a reasonable person as would overwhelm his capacity for reflection or restraint, and did actually produce such a state of mind in Mr. Scanlon. The provocation must be such that a reasonable person would have become incapable of reflection or restraint and would not have cooled off by the time of the killing, and that Mr. Scanlon himself was so provoked and did not cool off at the time of the killing. In addition, there must be a causal connection between the provocation, the heat of passion, and the killing. The killing must occur after the provocation and before there is sufficient time for the emotion to cool and must be the result of the state of mind induced by the provocation rather than by a pre-existing intent to kill or grievously injure, or an intent to kill formed after the capacity for reflection or restraint has returned. Mere words, no matter how insulting or abusive, do not ordinarily by themselves constitute reasonable provocation. The heat of passion must also be sudden. That is, the killing must have occurred before a reasonable person would have regained control of his emotions, and Mr. Scanlon must have acted in the heat of passion before he regained control of his emotions. If you find beyond a reasonable doubt that the Commonwealth has proven that Mr. Scanlon committed the crime of murder, but has failed to prove the absence of any mitigating circumstances beyond a reasonable doubt, you shall find Mr. Scanlon guilty of voluntary manslaughter. Your duty to return a verdict of the highest crime proven and jury unanimity. I've now instructed you on the crimes of first-degree murder, second-degree murder, and voluntary manslaughter. On this indictment, if you conclude beyond a reasonable doubt that Mr. Scanlon is guilty, you have a duty to return a verdict of guilty on the highest crime the Commonwealth has proved beyond a reasonable doubt against him, up to and including the charged offense of first-degree murder. And you should mark the appropriate space on the verdict slip which reflects your unanimous verdict. You will note that on the verdict slip, the theories of first-degree murder as well as second-degree murder and voluntary manslaughter are set forth. Before you may find Mr. Scanlon guilty of murder in the first degree, you must unanimously agree as a jury, that is 12 out of 12 deliberating jurors, on the theory or theories under which you are finding Mr. Scanlon guilty. You may find Mr. Scanlon guilty under more than one theory, but the jury must be unanimous on that verdict. That is, all 12 of you must agree as to each theory under which you find him guilty. You should address and deliberate on the evidence on each theory of first-degree murder separately and reach a conclusion about each theory separately. Thus, you may find that the Commonwealth has proved none of the two theories, one theory or two theories of first-degree murder against the defendant beyond a reasonable doubt. And you should indicate your verdict by checking the appropriate space or spaces on the verdict slip. If you have determined that the Commonwealth has failed to prove either first-degree or second-degree murder beyond a reasonable doubt, then you shall return a verdict of not guilty on this indictment and mark that space on the verdict slip. There's a second charge in this case presented to you, and that is assault and battery by means of a dangerous weapon. Mr. Scanlon is separately charged with having committed an intentional assault and battery by means of a dangerous weapon, specifically a knife on Ms. Avery. To prove Mr. Scanlon guilty of this offense, the Commonwealth must prove three things beyond a reasonable doubt, and this is on page 36. First, that Mr. Scanlon touched Ms. Avery, however slightly, without having any right or excuse for doing so. Second, that Mr. Scanlon intended to touch Ms. Avery. And third, that the touching was done with a dangerous weapon. The Commonwealth must prove beyond a reasonable doubt that Mr. Scanlon intended to touch Ms. Avery with a dangerous weapon in the sense that Mr. Scanlon consciously and deliberately intended the touching to occur and that the touching was not merely accidental or negligent. The Commonwealth is not required to prove that Mr. Scanlon specifically intended to cause injury to Ms. Avery for this charge. It is not necessary for the Commonwealth to prove that Mr. Scanlon actually caused injury to Ms. Avery with a dangerous weapon. Any slight touching is sufficient if it was done with a dangerous weapon. If the alleged weapon is not inherently dangerous, you must determine if it is a dangerous weapon. An item that is normally used for innocent purposes can become a dangerous weapon if it is intentionally used as a weapon in a dangerous or potentially dangerous fashion. Therefore, you must find beyond a reasonable doubt that where the weapon was not inherently dangerous, the defendant used it as a weapon with the intent to use it in a dangerous or potentially dangerous fashion. The law considers any item to be a dangerous weapon if it is intentionally used in a way that it reasonably appears to be capable of causing serious injury or death to another person. For example, a lighted cigarette can be a dangerous weapon if it is used to burn somebody, as is a pencil if it is aimed at someone's eyes. In deciding whether an item was intentionally used as a dangerous weapon, you may consider the circumstances surrounding the alleged crime, the nature, size, and shape of the item, and the way it was handled or controlled. If you find that the Commonwealth has proven all three elements beyond a reasonable doubt with respect to this charge, then you shall find Mr. Scanlon guilty of assault and battery with a dangerous weapon. If you find that the Commonwealth has failed to prove one or more elements beyond a reasonable doubt, then you shall find Mr. Scanlon not guilty of this charge. These will constitute my closing remarks to you. I'm about to submit this case to you for your consideration and your deliberation. I need not remind you that you'll have a grave responsibility in this case, but I know that you will bring to bear all of your wisdom, judgment, and conscience you possess in reaching verdicts on this case. I want you to understand that your responsibility in this case does not extend beyond certain areas. You are not responsible for the conduct of this trial. You're not responsible for anything this defendant may have done, if anything. You're not responsible for any punishment that may flow if it does. Those things are not your responsibility, and you must not be concerned with those matters when considering the evidence and working to reach a verdict. As I told you earlier, the verdict, whether guilty or not guilty, must be unanimous. The jury does not have a verdict unless and until all 12 deliberating jurors agree. You do not have a guilty verdict unless all 12 agree that it is guilty, and by the same token, you do not have a not guilty verdict unless all 12 agree that it is not guilty. All we ask of you is that you decide this case with integrity and principle. We all expect you to reach an impartial verdict without sympathy, without prejudice, and not prompted by any facts except those you've heard here in court during the trial of this case. All we want is a verdict dictated by your logic, because emotions have no place in the rendition of your verdict. We are looking for an impartial judgment dictated by your fair reasoning in the fullest discharge of the oaths that you all took as jurors when this case started. Now, some housekeeping matters. If during the course of your deliberations you should have a question about the law, the procedure you should follow is this. First, you must all agree on the form of the question. The foreperson, who I'll pick in a few moments, will have to write out that question and present it to the court officer, who will bring it to me. I will call the attorneys together. We will discuss the question and how I should respond to it. Then we will either bring you into the courtroom to respond to the question in person, if appropriate, and the parties agree. I will respond to your question in writing and return a written answer to the jury room, in which case you will just simply receive a writing by me and signed. The procedure that I've just discussed, that is, if you send a note out with a question, means that there may be a lag in time from when you ask the question to when I can respond to you. If possible, you should continue your deliberations while waiting for an answer to your question. If not, then stop until I can get a response to you. If it becomes necessary to communicate with me on any other matter, please send a note out via the court officer from the foreperson. No member of this jury should attempt to communicate with me by any other means other than a signed writing, and I will not communicate with any member of the jury on any subject touching on the merits of this case other than a signed writing. You are not to communicate with any of the court officers on any subject matter touching on the merits of this case. Your communications with the court officers should be about scheduling breaks, and when you come back to the courtroom, do not discuss with the court officers or anybody else what's going on in the jury room. Also, please keep this in mind. You are never to reveal to any person, not even to me, how you stand numerically on a particular charge until you have reached a unanimous verdict. Then and only then will you report your verdict here in open court unless I instruct you otherwise. I must now select a foreperson to assist in your deliberations.
Your Honor.
Yes.
May we approach before you the alternate selection?
couple things I want to talk to you about before I select the foreperson. There's a phone that's in evidence. I don't think you have a charger in evidence, but you're not to try to turn that on or look inside that phone or get inside that phone in any way. It is what it is. You're not to power it up and look at it at that time. Second, I did notice during the course of the charge that some of you were jotting down notes. I need to remind you, I said this when I started, the oral instructions here in court govern the law that you're to apply and nothing else. So to the extent, in any way, my oral instructions differ from the written instructions that I'll send in, it's the oral instructions that govern. To the extent that any of you jotted down any notes about when I was making a closing argument, when I was making a reading to you the law in this particular case, you must not use those notes as a substitute for the complete body of the law that I gave you during the course of these oral instructions. And as I said to you when we started, the instructions that I give you must be taken as a whole and not any one focus on any particular part, but you must regard the instructions as a whole. And again, if you have any questions about the law at any point in time, and by saying that, I'm not suggesting in any way that you should or even might. The procedure is not to speculate, but it is to write a note to me about what you want further instruction on, if possible, and then I'll get back to you in the manner that I've described to you, okay? So there's that. So now I need to turn my attention to selecting a foreperson. I've selected juror number 75 in C10 to be the foreperson for this case. The foreperson's vote or opinion is not entitled to any more weight than the vote or opinion of any other juror. Each member of the deliberating jury has an equal voice in the deliberations and an equal vote with respect to the verdict or the charge on the charge in this case. Charges in this case. We have a foreperson for two reasons. First is to help you organize yourself and to act as the group's facilitator of your discussions and your deliberations. And second is to report your verdict on behalf of the jury in open court when you've reached your verdict. I thank you in advance for this additional service. The foreperson's responsibility is to do the best that she can to make sure that the deliberations are conducted fairly, orderly, and efficiently. If everyone wants to talk at once, if there is no order to the proceedings, you will all probably feel very frustrated and feel like you are not making any progress to a resolution of this case. You must go about your business in a business-like fashion. Another situation which can sometimes arise in deliberations with a group of this size is that only a few jurors, usually the more vocally assertive, tend to dominate the discussion to the exclusion of others in the jury who are perhaps quieter, but whose views are nonetheless equally deserving of being heard. It would be unfortunate if an atmosphere develops whereby certain jurors are reluctant to put forth their views for fear that others in the jury might be quick to criticize or put down that juror or that juror's view. We look to the foreperson to make sure that everybody in the room that wishes to speak has a full and fair opportunity to contribute whatever they feel needs to be contributed. Now, reducing and sending out the jury. When we pick a jury at the beginning of a trial, we never know whether some personal emergency will arise during the trial which will require that one or more of the jurors be excused from further jury duty. To avoid having to start the trial all over again, if that should occur, and it has, we impanel 15 jurors, even though the case will eventually be decided by only 12 of you. The time has now come to reduce your number to that 12. The clerk will draw 3 of your juror numbers, the seats which you are sitting in, at random. These jurors will be designated as the first, second, and third alternate jurors and will not take part in the deliberations unless it is necessary to provide a substitute for one of the other jurors. Now, before we do that, I want to tell you, if fate, the draw, if you will, makes you an alternate juror, please do not take it personally. Your presence up to this point and your continuing availability, if you should be needed, is vital to this case and to the administration of justice. And we still need the alternate jurors to be available if one of the sitting jurors cannot continue. The court officers will make you as comfortable as possible while the jury deliberates. While that takes place, I will again ask the alternate jurors not to discuss this case among yourselves. Our clerk will now reduce this to 12.
Juror 15, you have been selected alternate, please call the court officer.
15.
Step down, come around, and have a seat here.
Juror 13, you have been selected as an alternate. Juror in seat 13, please call the court officer. Juror in seat 7, been selected as an alternate. Please follow the court officer.
So with respect to the alternates, and now we have our deliberating jury of 12, and we have our 3 alternates. It is important, it is crucial that the deliberating jury not discuss in any way with the alternates what is occurring during the jury deliberation process. You'll be kept separate from the deliberating jury, but there may be occasions when we're coming in and out of court, when you're lined up and so forth. You must not discuss in any way between the alternates and the deliberating jury what is occurring during the course of the deliberation at that time. As I've said earlier, to return a valid verdict on these charges, each deliberating juror must agree to that verdict. Each juror has a duty to consult with one another and to deliberate with a view to reaching an agreement if it can be done without violence to one's individual judgment. I'm sure I'm not telling you a secret when I say that a unanimous verdict of 12 deliberating jurors is not necessarily an easy task. It will require a very conscientious approach to your duty as jurors. I suggest that you each approach it with a mutual respect for the opinions of your fellow jurors, that you each have a disposition to listen to one another, to be convinced as to one another's judgments and persuaded as to one another's views. Don't be afraid to change your opinion if the discussion persuades you that you should. Don't hesitate to re-examine your own views and come to a different conclusion if you are convinced that your earlier conclusion was erroneous. But do not come to a decision simply because the other jurors think it is the correct decision. No juror should surrender his or her honest conviction as to the weight or the effect of the evidence solely because of the opinion of his or her fellow jurors or for the mere purpose of returning a verdict. Each of you must decide the case for yourselves, and you should do so only after you've considered all the evidence, discussed it fully and impartially with your fellow jurors, and listened to the views of your fellow jurors. You have all seen and heard the same evidence. You have done so with the same degree of attention. None of you are partisans. You are not advocates. You're judges of the facts of this case. I'm confident that you will discharge your duty faithfully as well as you work to reach a verdict on this case. The counsel need to see me at sidebar. All right? We now need to swear our court officers in. I suggest you pay attention to the oath that they take as well as they're taking it.
You all raise your right hands. Do you each solemnly swear that you will keep this jury together in some convenient place until they are discharged of their verdict, and that you will permit no person to speak to them nor speak to them yourselves except by order of the court or to ask them if they have agreed, so help you God?
So help me God.
Thank you.
So, jurors, I'm going to now send you out to begin your deliberations. We will send the exhibits into you in just a few moments after the attorneys and I have checked them to make sure that they're complete and appropriate. I will send you in, I'll have marked for identification a copy of what I read to you, and that will be brought in shortly thereafter. There are a few matters that I need to fix and reprint as I made corrections as I went through. So that may take a few more minutes than sending the exhibits in. I will now order you to go to the jury room and begin your deliberations on the case.
You bring your notepads this time. Jury exiting. All rise.
So I have a few changes to make. What I'm going to do is make them, print it, sign it, give it to Mr. Walsh. I'll send it out, you can check it out, and when it's okay, it can be sent in. I don't normally come out to talk to you about the exhibits before they go in, but if you need me, come in and have Mr. Walsh come get me. I can come out and do it. I just want to make sure that before the exhibits go in, the parties indicate that they're satisfied with the exhibits going in, as well as the a final jury instruction. So with that, I'll be available. Stepping up. I'm sorry, what's D? P for identification. Okay, thank you.
Thank you.
All rise.
All right, everybody. So that is closing arguments. I actually just ended up timing out just right that I ended up home and able to come in here and give a few thoughts. So I will be monitoring for a verdict, and when it comes in, we'll go live again. But ultimately, I think the defense did a good job making their argument. I mean, I think they did as good job as you could with this set of facts. I think what might resonate with the jury is the key fob and the fact that he hid those keys. I mean, that's something that a jury, when they go back to that jury room, could decide, you know what, that's proof enough for me that he was planning this, that he had seen her out. But I still think that to me, what should have really been pounded home was the fact that, you know, they have children together, they're living together, and her behaviors that night seem to be tailored towards attempting to inflame him. It doesn't justify a killing here, but what we're talking about here is the behavior is so egregious. He witnessed her having relations with another man in his car. Now, she does this knowing he's there. And again, the defense didn't explore this enough in terms of having the opportunity to have her cousin on and say, was this out of character behavior? In other words, was this normal behavior for her when she went out in the past? Is this how she normally acted? Or was this behavior that was out of character? And if it was out of character, then it was being done with an intent to inflame him. In my opinion, that speaks to the idea here that when she leaves, if her intent was to try to upset him and she goes home and continues to inflame him, it could be looked at as that being a continuation. As I said, I believe second degree is where this falls. I think there's going to be some debate in that jury room. I think it's going to be an in the middle situation, and that's where they're going to feel comfortable. Let me know what you think in the comments. But that's really where I think this should have pled out to. Save the taxpayers money, save the family having to go through a trial. The judge gets to decide how long they want to put him away for. He's still going to get life as a potential sentence, and he'll get a minimum of some sort that the state could argue. My opinion, what I think the judge should do in this case, what would have been, and the state should have argued, was 28 years, 1 year for every time he stabbed her, 28 years to life. And at the end of those 28 years, when he serves out those 28 stab wounds, let's see what type of man he is, and does he deserve to get out? Does he deserve to see the life of day? Does he deserve to do something to live in memorial of the life he took? That would be how I would do it. If I was the judge in this case, I would have said, okay, I'd accept that plea of second degree, 28 years, and we go home. Now, obviously, the state is reaching here for the idea of saying, well, and this is what I didn't like. I think it was a disingenuous argument to suggest that this is not like the John DeLee case where you're going to infer intent because you're in a fight situation. So the first one might be to get the person off, and then John DeLee shoots him 8 more times. So you could say, well, each one of those was premeditated. At some point, he's realizing boom, 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 boom. Although there's arguments to be made. But in this case, it's all part of a state of mind. And that's what I felt like the judge was trying to load the deck here against the defense by allowing the prosecutor to blur the facts and then lean on the fact that, well, closing arguments aren't evidence. Well, They aren't evidence, but you're also, as a member of the bar, not allowed to just misstate things, and you're not allowed to bring in things that are stricken or argue things that are stricken. There is limits. There is limits. It's not, you can't allow things to happen that are going to confuse the jury. And the defense doesn't get a chance to clean that up. So, I think, but I think, like I said, I think we're going to see a second degree here. The defense will feel like that's a victory because they saved them from life without parole. The state will say, hey, it's better than him being convicted of manslaughter. That's my thoughts. That's what I think we'll have. I think there's going to be some extended deliberations in terms of, I think this will last maybe 3 to 5 hours. I think they'll go back there. Now, it's possible, of course, but here's what I like to hear. They were taking notes, okay, meaning we have an attentive jury that wants to follow the law. So I don't think this is going to be a jury that's just going to walk back there and just go, first degree, that's it, we're going home. They sound like they really want to try to place this thing in the proper context, and I don't think there's a person in that room that can't figure out or that it doesn't at some level resonate what he witnessed, whether he intended it or not. I don't think he intended or thought that's what was going to happen, but listen, when you're in that moment, some people can't help themselves. So he goes out there. He looks when he shouldn't have looked. He saw something he shouldn't have seen. She gets out of the car and goes with him. It's inexplicable. What is she trying to do? It shows a body of work, an intentional willingness to inflame him. Now, did she expect she was going to be killed? No, of course not. But she was trying to inflame him and incite that passion inside of him for whatever reason. We don't know because there wasn't a lot of evidence presented about the relationship. But I think, to me, the nice place to fall here is second degree. I don't think this is the type of situation where it'd be different if he was sitting at home and never showed up at the bar and she shows up and he kills her out, But it's clear he didn't intend to kill her. It's clear he didn't have a plan. It's clear this emanated from a situation where there was passion inside it. There was anger. There was, it comes off as, okay, they arrive home, they're fighting, they're arguing, and this thing just elevates. But what he saw and what she does with that, do we get away from second degree and say, well, we'll excuse it and give him a maximum of 20 years, although the jury's not worried about the sentence? But do we get to manslaughter and say, no, I think manslaughter might have been if he had a knife on him, he opens the car door and just starts stabbing her, and then police come and she bleeds out and they say, okay, that's manslaughter. But in this case, I think there's enough here to suggest that there wasn't premeditation in the sense that he wasn't in a state of mind where he could have premeditated anything. And while, yes, there was cruelty, and yes, but it was not. It wasn't specifically intended to be cruel, because it was just, here's a set of facts. He's just witnessed this, and this whole thing blows up. Anyways, that's where I leave it. So we'll leave it at that, guys. I'm going to end the broadcast. I'm going to double check and make sure I'll check live. I will be monitoring this, and as soon as we have a verdict, as soon as they're back, we will fire up the stream and come back. Be checking out. I'm going to be doing a vertical live where we're going to be broadcasting some clips and footage from this case, maybe even putting up some old some of the Tyrone Tucker things up there to get that broadcast out to a larger group and see how that goes. And then we'll be doing a live later tonight as well. And then we'll make some decisions on what we cover next. Again, I'm not fully certain if we're going to roll into the Rancher case, or maybe we just might, maybe do a lighter schedule for the rest of the week, and pick up on whatever the next case is whenever it comes up. We'll see what we do. Anyways, appreciate you guys all watching. Hit the like button on the way out. Make sure you share this video, and we'll take it from there, guys. So as always, I appreciate you, and let justice prevail. We'll talk again when we have news on a verdict.